Hi, so we are going to be talking about anonymity, a really important area of law because if you get it wrong, it can get you into all sorts of trouble with the courts. So it's really important you understand when you can and when you cannot name somebody who appears in a court case or in a legal situation. So let's have a look at these. Whoa, there's a lot to learn, isn't there? So there's a whole range of groups and situations where you need to be aware that anonymity is offered to people, that you are not allowed to identify certain people. Generally, this is to do with vulnerable groups. So we're going to look in this video at juveniles, and we'll move it to another video where we'll look at sexual offences and human trafficking, and then we'll mop up on some of the other areas where anonymity can apply. Juveniles for this video, really important issue. So what have we got here? So here's an example of a recent court case, February 2021. This was the case where a 17-year-old was stabbed to death in Moss Side. So this is Mahmoud Mohammed, who was 17 and killed. 4 people were accused of killing him. You'll see that in that report, 3 of them are named, and they are 2 18-year-olds and 1 19-year-old. But a 4th one, a 17-year-old, was not named. And it says there, a 17-year-old boy who cannot be named for legal reasons. So there's something going on here. So there's something in the law clearly which says that we cannot name that 17-year-old, but we can name a 17-year-old victim in this case, but we can name an 18-year-old and a 19-year-old. So something's going on, so we need to understand that. And so we'll come back to this example after we've been through some of the details of the law, so to try and understand why that report is structured in that way. And similarly, another example with the sad death of Yusuf Maki, a 17-year-old down in near Altrincham back in 2019, so just 2 years ago, a bit less than 2 years ago. It was a big story in Greater Manchester and also went nationally. You see The Guardian, various other national organisations covered it. So when we look at the MEN report, you can see in here we're naming Yusuf Maki, the victims, who was 17. But then it talks about 2 other 17-year-olds who were arrested and charged with various offences in connection with the death of Yusuf Maki. So they're 17 years old. It's saying that they're appearing in the youth court, and we are not naming them in this report, those 17-year-olds. So again, why are we able to name Yusuf Maki, who's 17, and we're not able to name the 2 17-year-olds who are accused of being involved in his death? Similarly, the Guardian, obviously the same rules are applying because they're naming Yusuf Maki, but they're talking about this 17-year-old suspect who cannot be named, it says, talking about the youth court as well. So something's going on, something that you need to understand in order to be able to report on cases like this safely. So let's have a look at the law. So as always, I'd like you to be able to identify the law, the key bits of legislation. So there's 2 key pieces of legislation which determine when we can and we cannot name juveniles. So there's the Children and Young Persons Act 1933. That's a really important piece of legislation. Then there's the Youth Justice and Criminal Evidence Act 1999. So you need to know those 2 pieces of legislation. They're really important. Also, you need to be aware that there are different types of identity ban depending on the type of court that somebody appears in. So there's an automatic identity ban, automatic anonymity in certain situations, or there's what they call a discretionary identity ban in other situations. By discretionary, it means that the court decides whether to place or to give someone anonymity, whether to ban the identity of somebody or not. So either it's automatic or discretionary. So just be clear on that. So it's going back to those pieces of legislation. So I said there's 2 bits of legislation But within those two bits of legislation, there are a couple of different sections. So I'm going to be mentioning these sections through this bit of the lecture, and I don't want you to get too lost in them. So just to make the point that there's under the Children and Young Persons Act 1933, there's really three sections you need to be aware of. Well, I won't go into the detail now, but sections 39, 47 and 49 are the important ones for the purposes of this lecture. And then the Youth Justice and Criminal Evidence Act 1999, that's the other piece of legislation. There's one section really in there which is absolutely key importance, which is section 45. But don't get too bogged down in that. As long as you're aware that there are two key bits of legislation, then we'll get into the sections as we go through. So first of all, we're talking about juveniles. So the big obvious question is, what is a juvenile? Well, under the law, the age of criminal responsibility is 10 years old. So before you're 10 years old, you cannot be held criminally responsible for your actions. So you cannot be prosecuted with a crime before you are 10 years old. As soon as you're 10, you can be prosecuted with a crime. So the law also defines a child as being someone who's under the age of 14. So that's an important definition. And then the law describes people who are aged 14 to 17 as young people. So just be aware that there are specific meanings to these words. They're not interchangeable. They talk about a child or they talk about a young person. It means two different things. And it has an impact on the way they're treated in court and the sentences that they might get. The key thing is that up to the age of 17, all of these categories are regarded as juveniles. So it takes is a catch-all phrase for child and young people. So anyone under the age of 18 is a juvenile. So let's have a look through these things. We said that we're going to look at juveniles, what happens in youth courts, then we're going to look at what happens in adult courts, and then we're going to look at what the codes of practice say, the IPSO and Ofcom editors codes, when we're talking about juveniles. So let's get going. So I've put together this diagram. I hope it helps. And you'll see those different sections of each of the acts we mentioned in there. And I'm going to run through this little diagram. I'm hoping just to try and make it a little bit clearer, because you can get a little bit lost in amongst all these different scenarios. But let's just go through step by step, and hopefully it'll become clear. So we're talking about juveniles, so that's people who are under the age of 18. After you're once you're 18, you're regarded as an adult. So this is all about people who are under the age of 18. So let's start with people who are under the age of 18, juveniles appearing in youth courts. You remember youth courts are based with the magistrates, but they're a very special kind of court where there's restricted access. They appear much more informal, so as not to be intimidating for young people. And there are specific restrictions which apply in youth courts. We spoke about them in week one when we were looking through the courts. So to start with, in youth courts, there is an automatic identity ban. You cannot name any juvenile who's appearing in a youth court, and that's enshrined under the Section 49 of the Children and Young Persons Act 1933. So we'll come on to that in a moment. But just a reminder of what youth courts are. They are the courts that deal with most cases involving juveniles, people under the age of 18. Access to a youth court, the public is excluded, but journalists are permitted. And that's that permission for us to go in as journalists is under Section 47 of the Children and Young Persons Act. So remember, that's one of the sections I've mentioned. And then there's another section, just two sections on, Section 49, which provides for automatic reporting restrictions, which means they don't have to place those reporting restrictions on. They don't have to mention them. As soon as a juvenile, someone under the age of 18, appears in a youth court, the ban on identifying them applies. So you can get access to a youth court as a journalist through Section 47 of the Children and Young Persons Act, and you have to observe the automatic reporting restrictions that apply to a youth court, including an automatic ban on identifying a defendant, but also a witness and possibly a victim if they're appearing in the youth court to give evidence. Then there's an automatic ban on identifying any of those under Section 49 of the Children and Young Persons Act 1933. So important to know that. So what do we mean by an identity ban? Well, clearly you mustn't name them because that's a key part of your identity, but it's more than just your name. It's your address, school, anything which would identify someone under the age of 18. So it's really important you don't use if they have distinguishing characteristics, if they have something which makes them very identifiable, you can't describe that thing. If they have a very distinctive voice, whatever it might be, no information which would identify them to people who would know them, or people who don't know them, but you would imagine that they're being identified to people, to close friends, etc. Make sure you don't provide any information that would identify them to a close friend. And obviously, no pictures and no videos of juveniles involved in the youth court. Just to mention that that automatic ban also applies to appeals. So if a case that's appeared and dealt with in a youth court is sent up to a higher court on an appeal, then that automatic ban continues to apply. So just be aware of that. Note that the automatic ban under Section 49 of the Children and Young Persons Act 1933 does not apply to dead juveniles. So if there is a case of a juvenile who's been accused of killing another young person, another person under the age of 18, you would be able to name the dead youth, but you would not be able to name the young person who is accused of killing them when they're appearing in the youth court. Also important to remember that this applies only to juveniles. So as soon as somebody becomes 18, as soon as they have their 18th birthday, that automatic right to anonymity expires, and they no longer have that anonymity. So you are then able to identify them as you would any adult. It is possible for a court to lift the ban, but you have to wait for the court to lift that ban, and if they believe that not identifying someone could cause an injustice, or there's a public interest or anything like that, if the court decides that the anonymity is causing problems to the judicial process, then they'll lift it. But you have to wait for that court to lift it. You can't just decide under your own steam that it should be lifted. You have to wait for that permission to do that. So here's an example, going back to that Yusuf Maki case, of the sorts of things that we can include when somebody appears in youth court. So on that Yusuf Maki case, we have details of the 17-year-old who they don't name, they don't give any details of where they're from, but they do provide some fairly bland information, dressed in a grey jumper and black trousers. Well, if they were in a rainbow jumper and sparkly trousers, you might say to yourself, well, there's not that many people who would wear that sort of clothes, those sorts of clothes, when they're 17. So maybe they are not. So, but that could be information which could be used to identify somebody. But a grey jumper and black trousers, that couldn't be used to identify a particular person. So they were safe to use that. So they've chosen to do that, but only because it was bland information which did not go to identify that 17-year-old who was appearing in a youth court. Okay, so that's youth courts. Moving on to adult courts, we now move on to a different piece of law which creates a discretionary identification ban in adult courts. So remember, adult courts, so once we move outside of youth courts, we have magistrates courts, which are adult courts, and we have crown courts, which are adult courts which might deal with the most serious forms of crime. So it is possible that a juvenile could be moved from a youth court to be dealt with in an adult court if there are various situations. So if, for instance, their co-accused is an adult. So we saw in the case of the lad stabbed from Moss side, and the example I gave you from February this year. In that case, there were 3 adults, 2 18-year-olds and a 19-year-old, and 1 17-year-old. So they want to tie the whole case together. So the adults can't be dealt with in the youth court. So they move the juvenile into the adult court to stand alongside the co-accused. So that can happen. So they step outside of the youth court in that case. Obviously, if someone's been charged with a really serious offence like a murder, then a youth court can't deal with that. They don't have the sentencing powers because that's done at the magistrate's level. They have to be moved up to the senior court, up to the Crown Court, to be dealt with, in which case they've been moved into an adult court. So this is what the law says about anonymity in adult courts. So it's a discretionary ban. So it's up to the court whether they apply the identification ban or not under Section 45 of the Youth Justice and Criminal Evidence Act 1999. So that's one of those bits of law I mentioned, the Youth Justice and Criminal Evidence Act 1999, and it's Section 45 that you need to be aware of. So you can see it up there in the little diagram. I'm just giving you a little prompt up there. We can see that if a juvenile appears in a adult criminal court, like a Crown Court, that would be the most likely place for them to appear, and it's up to the court to apply that identification ban. If they don't apply that identification ban, if they don't grant anonymity to that juvenile, you could name them. It would be possible. You wouldn't be breaking the law, but you need to be really careful that you don't just think, oh, I'll just be clever here because I can see that they've not passed an order. It could be that you just got it wrong and you didn't notice when they passed it. So if you think you're being clever, you might actually get it wrong. Or it also would show bad faith to the court if you just thought, well, they've just sort of forgotten to pass it. It would always be good practice to check with the court to say, are you sure you're not going to be passing a discretionary order on this juvenile? And it would help certainly your reputation in that court if you are flagging it up before you actually just went ahead and reported on a juvenile's identity when you think the court's just forgotten to ban it. So Section 45, Youth Justice and Criminal Evidence Act, is a order which an adult court can place on the identity of a juvenile. So what does that order say? Well, the order says we should not reveal, again, the name, the address, school, anything which is likely to identify that juvenile, and any picture or video of that juvenile. It's really important to be careful with pictures and videos. So I fell foul of the law once where we had a picture of a juvenile appearing in an adult court. I knew there was an order, so we couldn't name him, but we had a picture of them outside court doing a V sign to the camera. So they'd been dealt with by the court, so we thought it was okay to use that picture, but we'll pixelate their face. The court got in touch to say that they felt that we had identified the young person, even though we hadn't given their name and we hadn't shown their face, because they were wearing a distinctive jumper which had stripes on, and they said that anyone who knew the youth involved would know them from that jumper, and so it caused all sorts of trouble because we thought we were staying within the law, but the court felt differently. So you need to be really careful. Anything which is distinctive about a picture you mustn't use, otherwise someone might identify them. And just to stress that when they say publication, that includes social media, web, everything. So in that Yusuf Maki case, just using the Guardian article here, you can see that says the offence was too serious to be heard at the youth court. So this is an example of an offence where someone's been killed. That juvenile could not appear in the youth court, would not be dealt with in the youth court, so it had to be moved up to the adult court. And when it got to the adult court, they placed a Section 45 order on it, banning the identity of that 17-year-old, that young person who was accused of being involved in the killing of Yusuf Maki. So, and that's the last piece, and this is not such a big area from most of our professional lives. But in the civil courts, you remember civil courts where there's disputes between individuals, people are suing each other. It's very unlikely you're going to end up with a juvenile in there. But if you were to get a juvenile, someone under the age of 18, then there is a separate piece of law which covers that. And it's again a discretionary ban. It's up to the court whether they apply it or not. And that's Section 39 of the Children and Young Persons Act 1933. So again, this is the same piece of law, the Children and Young Persons Act 1933, which applies to the youth courts, but it's a different section. So in this case, it's Section 39. Remember, in the youth court, it was Section 49. So don't get too muddled up with all those sections. You'll see I listed them at the beginning of this lecture. So let's go through there. There were just a handful of sections to remember, just 2 pieces of legislation. So don't get too lost in it. Set them out in a clear and easy way in your revision notes, and you'll be fine. Just have to remember which ones apply to which situation. And again, the point with an order is that you can't identify all those normal things: name, address, school, anything at all, or which identifies them, or any picture or video. Be aware, we saw with the automatic anonymity in the youth court that there were limits on that anonymity, and so similarly with discretionary bans, these bans which are placed on the identification of juveniles in adult courts, that they can't be used to ban the identification of a dead juvenile. So once someone is dead, that anonymity expires. Then you can go ahead and name them once they're dead. It also expires, as it did with the youth court. The anonymity expires on their 18th birthday, but it is always wise to check rather than just going ahead. If you're partway through a case and somebody who you know is appearing in court, you think they've had their 18th birthday, it's wise to check with the court, to keep good faith with the court, rather than just thinking you're being clever and think, oh, today I'm going to name them because I think it's their birthday. Because you never know. Maybe you're going to get their birthday wrong, or there might be something else which the court, another reason the court might want to ban their identity. So just be a bit cautious. But on their 18th birthday, you can name them. It's important to be aware that the courts do sometimes misuse discretionary bans. Particularly in Crown Courts. So remember, we're talking about Section 45 of the Youth Justice and Criminal Evidence Act, where the court, an adult court, has chosen to issue a ban on identifying a juvenile. They shouldn't just issue a Section 45 on every juvenile that appears in the court. They have to have a good reason for each particular juvenile, so they need to give good reason. If they don't give good reason, you can challenge it. We'll talk about that in a moment. And also, it's important that the courts don't use Section 45, these bans on identifying juveniles, as a way of sneakily banning the identity of an adult who's appearing. So if they were to, for instance, ban the identity of someone who's accused of a crime, if their child is a witness, for instance, if the court issued a ban on that child, that would therefore mean you would be very difficult to report on the case and report on the relationship or the name of the defendant. So the court should not use a Section 45 in a Crown Court or a Section 39 in a civil court to effectively ban the identity of an adult. That's not what they're there for. They're there to protect specifically vulnerable young people, and they have to have a reason why they use it. Ta-da! There we are. So hopefully that diagram helps make sense. As you can see, when you lay it out like that, basically, you've got juveniles. Be aware that they're a vulnerable group, and there are rules about identifying them. When you're in youth courts, it's an automatic ban. When you're in adult courts, whether in an adult criminal court or an adult civil court, there's a discretionary ban which applies. So let's be aware of that. I mentioned challenging identification bans. So this was a case, sad case, fairly recent. I think it's a year, 18 months ago or so, of a young girl who was abducted and killed. I think it was in Orkney in Scotland. But it illustrates a useful principle that the identity of the boy who had killed the child, he was 16, so he was regarded as a young person himself, and there was an order banning his identification throughout the trial when he was standing trial for murder. When the verdict came back that he was guilty of murder, there was an application by a number of newspapers to say, well, this boy might be 16, but he's now been found guilty, that he's going to be detained, so he's not going to be out on the street. So therefore, there really can be no harm in naming him at this point. And the courts agreed, and the very next day, the identity ban was lifted, and hey presto, we had pictures and the name of the 16-year-old killer. But it has to be formally done by the court. You cannot just make that decision yourself. You have to apply to the court. And the way to apply to the court, you approach the clerk, the person who sits in front of the judge, during a suitable moment in a lull in proceedings, and tell them that you want to challenge an order. They'll usually ask you to do that in writing. So you should say on what grounds you are challenging the order. And then it will be considered by the court. One thing I should mention is that orders traditionally should be posted on the door of the court. So when you go into a courtroom, always check the door, because it should, that order saying that there's a ban on that case, on the identity on that case, and this is true of all orders to do with a case, should be on the door of the court. But again, it's always worth double checking. I got into trouble as an editor when one of my reporters gave some information which was banned by an order, and the order had not been posted on the door, but it was available at the front desk of that particular court. So you should always check, make sure you're checking around whether there's any orders relating to a case, but always check the door as you walk into the courtroom, not the front door to the building, the actual door going into the courtroom itself. If you were to break an order, whether that be Section 49 or Section 45 or Section 39 order, there could be an unlimited fine, or you could be prosecuted for contempt of court. And as you might remember from the contempt week, you could spend up to 2 years in prison for being in contempt of court. So you really don't want to break it. I always talk to you about defences. It's a difficult one to defend, if I am honest. So in this particular case, for breaching an order, whether automatic or discretionary, identity ban, under the Youth Justice and Criminal Evidence Act, you could use Section 50. You could say the publisher was not aware or that has reason to believe that they breached the anonymity order. Or you could use another part of Section 50, that the victim or witness had given their consent, their written consent. So it must be written consent. But you can't do that while you're under the age of 18. You can't give that written consent. So it's a difficult one to defend. So the most important thing really is just don't breach the order. So let's go back to those examples we saw at the beginning. So here we have the case of Mahmoud Mohammed, who was stabbed to death in Manchester, the case which took place or finished in February. So now that we've got an idea of the law, so we can see that Mahmoud Mohammed was named, even though he's 17, so he's a juvenile, but he's dead. So therefore the anonymity that was given to might have been given to him does not apply or cannot be applied to a dead juvenile. So we can see that that's the reason for that. When we come to the 17-year-old who was accused of and convicted of being connected to the killing, well, he's 17. So he's appeared, we can see at the bottom there, he appeared in Manchester Crown Court, so that's an adult court. So that means that there had to be an order, but an Section 45 order passed on this case to ban the identity, a discretionary ban on the identity of that 17-year-old boy. We know that it's an adult court because it says that it's Manchester Crown Court, so the discretionary order would have been placed on that 17-year-old. However, the other three people who were accused and convicted, they're 18 or 19, which means that they are adults in the eyes of the law, and therefore there is no ban on their identity. When that 17-year-old who's not named here, when they appeared in the youth court initially, because remember they all would have come through the magistrates initially, which means a 17-year-old would have first appeared in a youth court because he's a juvenile. There would have been an automatic ban on their identity at that point. So when they were passed on up to the adult court, because they are co-accused with 3 adults, so they had to be moved up to the Crown Court, plus the fact that it's a very serious crime. I believe it was manslaughter that they were ultimately manslaughter they were convicted of, so they were charged with manslaughter, so they had to be moved on up to the adult court because it was such a serious crime. So for various reasons they were moved up to the adult court. So there's what applied there. So Youth Justice and Criminal Evidence Act, Section 45, a discretionary ban in an adult court. So that's what applied in that particular case. In the Yusuf Macky case, we saw those reports, we saw that the people accused could not be named for legal reasons, and these articles were written when the person appeared in the youth court, or the people appeared in the youth court. At that point, it was the Children and Young Persons Act 1933, the Section 49 order, which applied. It's an automatic identification ban in a youth court. So because those 17-year-olds were appearing in a youth court at that point, we could not name them. And the court did not have to place a ban, a discretionary ban on them, because by virtue of the fact it's a youth court, there's a ban on identifying any juveniles who appear. Again, you can see the information that was published. We looked at this earlier on. And again, it's youth court, automatic ban, Section 49, Children and Young Persons Act 1933. Just looking at how that case progressed, this case, because it was they were accused of having killed this schoolboy, when they had to be moved on up to the adult court because it was such a serious crime, and crime of murder. They were accused of the crime of murder. When they appeared in the adult court, that court had to impose a discretionary ban. As it happened, they were found not guilty of the murder, but they were convicted of a number of other slightly less serious crimes, but they'd appeared in the adult court. And you'll see the MEN reporting there, 2 youths, boys aged 17 who cannot be named for legal reasons. And hey presto, that's the reason there. Youth Justice and Criminal Evidence Act 1999, Section 45, discretionary ban in the adult criminal court. So the court had placed an order on banning their identity. So that's the reason we could not name them there. Just as a bit of a postscript, sometime afterwards, the Manchester Evening News reporter John Shearhout had kept an eye on the age of one of those 17-year-olds who was involved in killing Yusuf Macky, and there we go. Some time afterwards, this is October the 6th, 2020, so a long time afterwards, when that one of those lads had their 18th birthday, the reporter was then able to identify him. You can see he's now named as Joshua Molnar. Turned 18, he's a former Cheadle Hulme school pupil, and as soon as that discretionary ban expired on his 18th birthday, could tell a much fuller story, because you could say he was at the same school as Yusuf Macky, talk about the relationship between them, all things which we could not say before, because that would have given away the identity of that pupil. So you can see that a bit of clever reporting by putting in your diary when someone's birthday comes up, but it's always worth to be double really check on your facts, make sure you've got that right. But it's a great example of how an identity ban, a discretionary ban, has expired, and that's given the reporter another story. Okay, just last bit is to just talk about what the codes say about juveniles. Basically, the two codes differ slightly. The Ofcom code is slightly more conservative, so it protects anyone under the age of 18. So in terms of approaching juveniles, young people, for interviews or for anything, it says you really should have parental permission if you're talking to anyone under the age of 18, and certainly if you're identifying someone under the age of 18. IPSO has a slightly different approach, and it sets it as under 16. So remember, this is the ethical code, it's different to the law, but it says that if you're preparing an article for print or online, you can talk to 17 and 18-year-olds, but under the age of 16. So if as soon as they turn 16, you can talk to them. Under the age of 16, you should get parental permission, and you should be very careful about identifying them. So make sure you're looking at those ethical codes in parallel to the law, looking at those clauses. In particular, Clause 6 and Clause 7 of the Ipso Editor's Code are very useful. Okay, so that's juveniles. I'm going to move on now to the issue of sexual offences. As I mentioned earlier on, just to warn you that the next video I will be talking about sexual offences and using some case studies which are by the very nature involving the issue of sexual offences. So if you would find that disturbing, feel free to not look at that, but do read chapters 10 and 11 in Mays, which sets out the law. It's really important you understand the law relating to anonymity as far as sexual offences is concerned. See you in the next video.